Donna Adelson's trial is set to begin September 17th. But hold on a second. The defense just filed a motion to dismiss the case. That's right. Dismiss the indictment, send Donna Adelson home or to Vietnam, wherever she wants to go, because she should be let free. All of the charges and this indictment should be thrown out. Now, is there any basis for this in the law? Is this just a frivolous filing by the defense, a Hail Mary at the last minute to try to win this case and not have her stand in a trial which she's most likely going to lose? Is there any sort of legal basis behind this? Well, that is exactly what we're going to dive into today, and we'll see what type of arguments could be made by the prosecution against this, if this even has any sort of merit. So we're going to be jumping into the law like we always do. We don't just cite the facts and report on what's been filed. We actually look into the law and see if there's any sort of legal basis for what the parties are claiming in this case. So let's jump into it right away. So everybody understands that there is a Sixth Amendment guarantee, a right that everybody has to a speedy trial. So the government can't just arrest you, throw you into prison, and say, you know what, we'll try you in a few years, have a nice time in jail until we figure out what we're doing. They can't do that, right? Everybody has a right to a speedy trial. So the question is going to be, what about before you're arrested? What about before you're indicted? Is there also some sort of constitutional right that you have to be indicted timely as well? Can the government sit on a crime that you committed, wait 25 years, and then come and charge you with that crime? Well, the answer to this is pretty simple. No, they're not allowed to do that generally either. There is a constitutional guarantee. It's under the Due Process Clause, Fifth Amendment, the 14th Amendment, that even when the government knows that you committed a crime, they can't just not charge you and not indict you and wait, and then after all the witnesses that would help you died or relocated or unavailable, then charge you. They can't do that either. That's pretty straightforward. The question is going to be, what's considered a delay? And at what point is this considered a constitutional violation? All right, so two things very clear. Number one, Sixth Amendment guarantee to speedy trial. Everybody has that. That starts after you indicted, after you've been charged. But there's also a due process guarantee that the government can't just sit and wait to indict you for a tactical advantage. And we're going to see about the law about this in a minute, because the law is actually very interesting, as sometimes the law is in Florida. So that's also something that we're going to be doing on this channel, which you're probably not going to be getting on any other channel, is they're actually going to explain what led up to this law and how the law actually changed in a very big way, which actually is going to make the defense's job a lot harder in this case. So we're going to see all that also. So let's start with what the law used to be in Florida. The law used to be in Florida the following, and this is taken out of a case called Rogers. And this is what it says. When a defendant asserts a due process violation based on pre-indictment delay, he bears the initial burden of showing actual prejudice. So the defendant has the first burden. He's required to show, or she is required to show, that there's actual prejudice that he suffered as a result of this delay, of not being charged timely. You sat on your hands and didn't charge me for years. So now we have to show actual prejudice. That's number one. Now, continues. If the defendant meets this initial burden, the court then must balance the demonstrable reasons for delay against the gravity of the particular prejudice on a case-by-case basis. So now what they have to do is they have to engage in a balancing act. The outcome turns on whether the delay violates the fundamental conception of justice, decency, and fair play embodied in the Bill of Rights and 14th Amendment. So then we have to start weighing the delay. Number one, first the defendant has to show actual prejudice. Number two, now the court has to engage in some sort of balancing act to decide whether this delay was justified. Is there any sort of justification in this delay? And then weigh that against the prejudice. That's what it used to be. And that actually was a little bit easier on the defendant to prove, a little bit easier for him to prove that his due process rights were violated. But then things changed. Things changed in 2022. Okay, just 2 years ago. things changed. And that was the case of Jackson versus State. And this is what Jackson versus State says. Thus, based on the analysis above, we recede from the Rogers balancing test. So they're throwing out this balancing test. They're not just throwing that out, by the way. Listen to this. We now align ourselves with the majority of federal circuit courts and hold that a due process claim for a pre-indictment delay requires a showing of substantial prejudice to the defendant. So number one, the defendant has to show a substantial prejudice, not just actual prejudice. That's one step below that. I'm actually prejudiced by this delay. That's easier to prove than I have been substantially prejudiced by this delay. So now they have to show substantial prejudice. And number two, bad faith on the part of the state. So they have to show bad faith, not just that. Is there any sort of justifiable reason that the state waited? And what's the difference? The difference is very simple. Under the test before Jackson versus State, if the state was negligent in not prosecuting a claim, they forgot about it. They just forgot to prosecute this person, and they woke up later. Well, was there any reason for them delaying? Was there any sort of justification for them delaying? No, there's no justification. They were negligent. Well, under the previous test, then the defendant has met his burden because they have not shown any justification in the delay. But under Jackson versus State, negligence is not enough. It has to be bad faith. The prosecution had to have intended this, that they were acting in bad faith. So it's much harder to prove for a defendant to prove right now, the way the law is in Florida, to prove that this delay violated his due process rights. All right. So there's one more case which is very important, which talks about bad faith. Once you know these next few steps, then you're going to know how to analyze what happened and what the arguments are for Donna Adelson. On Donna Adelson's what her defense team is arguing. You're going to be able to understand it all and see how to analyze it. So this case is U.S. versus Foxman, and this is what it said. We have said that delay, which is the product of bad faith government acts, will satisfy this test. In context, we think those cases used the words bad faith to mean that the government acted to delay an indictment, hoping that the delay in and of itself would prejudice the defense. In bad faith cases, the government intentionally acts to delay, and the tactical advantage sought is the prejudice to the defendant, which the government anticipates will flow from the delay. And then they say it doesn't have to be that the government is sinister, that they have some sort of subjective, sinister motive here. The point here is, did the government delay for a tactical advantage? Is that why they delayed this indictment? Then, if you show that they did that for a tactical advantage, then that will equal bad faith. So number one, at this point, the way the law is in Florida since 2022 is that you have to show, number one, substantial prejudice, number one, and that's going to actually be a big difference in this motion. And number two is that the state did it for a tactical advantage. All right. So now with that backdrop, with that understanding now that we have in the case law, let's see what the defendants filed in this motion. We're going to go through it and we'll see whether they have met their burden. And we'll see what the arguments that Georgia Kopman will make back in response to this motion. All right, so here we go. This case presents an egregious example of pre-indictment delay. The state began its investigation with Mrs. Adelson among its prime suspects, just hours after Professor Markel's murder in July 2014. So Mrs. Adelson was already a prime suspect in 2014. Again, this is all going to be the defense's motion. By 2016, the state had focused its efforts through witness interviews, document subpoenas, pen registers, surveillance, undercover operations, and wiretaps to charge her alongside her alleged co-conspirators. So by 2016, the state already conducted this very thorough investigation, and they could have charged her then in 2016. In fact, the state's evidence against Mrs. Adelson, again referring to Donna Adelson, has remained largely unchanged since then. So they're arguing, one of the themes that they're going to be arguing in this motion is that they had all of the evidence already since 2016. There was no reason at all to not charge Donna Adelson in 2016. They could have done it. The only possible, again, this is their argument, the only possible explanation is that they delayed for a tactical advantage. Okay, that's what they need to show here. So that's why they're setting it up this way. Yet, the state made the intentional, strategic decision not to charge Mrs. Adelson for almost 8 years, choosing instead to pursue charges against 4 of her purported co-conspirators first. When the state finally decided to seek an indictment against Mrs. Adelson, more than 9 years had passed since the murder. By that point, exculpatory documents critical to her defense that the state never saw fit to even obtain, including cell phone records to refute the state's call pattern claims and SunPass records to refute the state's unsubstantiated and inaccurate suggestion of a money drop, were lost to foreseeable document retention policies, causing substantial prejudice, those magic words, to her defense. Accordingly, the indictment should be dismissed as a violation of Mrs. Adelson's due process rights. But you always want to ask for an alternative in case the judge is not going to throw this case out, which he most likely is not going to. So they want alternative relief in case the judge is not going to throw the case out. But if the court is unwilling to do so, at a minimum, it should preclude the state from introducing evidence that Mrs. Adelson can no longer defend against because of the state's charging delay. So they want to preclude any of this evidence, which they're going to go into a little bit more detail as we get into the facts of their motion. All right. So if they're not going to dismiss the case, at least you should preclude certain evidence from being shown to the jury. Professor Markel was murdered on July 18th, 2014. Within hours, the state located his former wife, Wendy Adelson, and brought her to the Tallahassee Police Department. During the hours-long interview that followed, Wendy confirmed that she and Professor Markel had been embroiled in an acrimonious divorce and that her parents, her mother included, were very angry at him. So right away, from Wendy Adelson's interview, the police knew that Wendy Adelson's mother, Donna Adelson, was very angry. Oh, there's a motive. So right away, the police could have been investigating Donna Adelson and could have been charging her. From that moment on, Mrs. Adelson was one of the principal targets of the state's investigation. So they want to show, the defense wants to show how Mrs. Adelson should have been on their radar from day one and what took them so long to indict her. Over the ensuing weeks and months, the state, joined by the federal government, devoted substantial resources to its investigation to support its theory that Mrs. Adelson was part of a murder-for-hire conspiracy. The state questioned witnesses at length about Mrs. Adelson and her relationship with Wendy and Professor Markel. It subpoenaed and combed through Mrs. Adelson's personal and business financial records going back to January 2013, and that's an important date, January 2013, which we're going to hear a little bit more about soon. It reviewed hundreds of emails between Mrs. Adelson, Wendy Adelson, and Charles Adelson. It reviewed Mrs. Adelson's calls and text messages, having filed applications with the court to obtain call detail records for cellular phones belonging to Wendy, Charles, and Harvey Adelson. And of course, in 2016, it conducted in-person and wiretape surveillance of Mrs. Adelson as part of the month-long undercover operations known as the Bump. By May 2016, the state had in hand virtually all of the evidence it is likely to present when Mrs. Adelson's trial convenes next month, almost a decade later. So again, they're trying to show they had all of this evidence, all the evidence they can possibly need to indict Donna Adelson in May 2016, yet they chose not to until 2024. But the state did not charge her in 2016. Instead, it made the strategic decision, that's bold and italicized because they want to show that this is all about getting an advantage. It made the strategic decision to pursue charges against the shooters and Mrs. Magbanua first, hoping that they would plead guilty and reveal what the state believes was Mrs. Adelson's involvement. But that did not happen. And so Mrs. Adelson remained uncharged through 2 trials, one in 2019 and another in 2022. The state also failed to charge Mrs. Adelson when it charged Charles Adelson in 2022. Once again, the state chose to delay. It wasn't until after Charles' conviction, with no new evidence to bolster its case, that the state brought charges against Mrs. Adelson on November 15th, 2023. I'm sorry if I mentioned 2024 earlier. No, it was actually November 15th, 2023, 9.5 years after Professor Markel's death. That is when the state decided, all of a sudden, to bring charges against Donna Adelson. All right, and then, as we spoke about, they bring the case law, which we went over and explained about what they need to prove in this case, which is substantial prejudice, and not just actual prejudice, but substantial prejudice. And number two, bad faith. So this is what their argument is for substantial prejudice. We anticipate that the state will present evidence through Tallahassee Police Sergeant Christopher Corbett of calls and text messages clustered around events of obvious significance. The murder in July 2014, and what the state has characterized as the first murder attempt in June 2014. So we have the first murder attempt, as everyone who's been following this case knows, we have the first attempt, or what they're arguing is the first attempt in June 2014, and then we have the July 2014 actual murder. And they presented, this Christopher Corbett presented how these cluster of text messages and these patterns of text messages and phone calls between Donna Adelson and Charles Adelson and Katie Magbanua, and we've seen all those clusters, and they're trying to show that obviously there's a lot of action now because they all know what's going on here. They're all part of it. They all conspire to do it. So, and opine that these clusters, which include communications to and from Mrs. Adelson, are consistent with her participation in a murder for hire conspiracy. The problem with the state's theory, however, is that its sample size is far too small and biased. That is, the state's analysis only included cell phone activity between May 2014 and July 2014. So they're only showing the jury these patterns and clusters of communications between Don Adelson and Charles Adelson and Katie Magbanua and Sigfredo Garcia, right? So they're only going to show that what happened between May 2014 and July 2014. And that's only 3 months. Had the state looked at a broader time period, one that began in 2013, for example. Now, why are they picking 2013? Well, remember we mentioned how they subpoenaed Donna's financial records from January 2013. So that's going to come in here. Had the state looked at a broader time period, one that began in 2013, for example, or even earlier, it would have seen similar call patterns clustered around dates and events that had nothing to do with Professor Markel's murder. So if you're only going to look, this is what the argument is. If you're only going to look at the patterns and clusters of phone activity from May 2014 to July 2014, yeah, it certainly looks like Donna knew what was going on and she was involved. But if they would actually look going all the way back to January 2013, they would have seen the same type of patterns and clusters going back all the way from January 2013, which would show, obviously, that Donna actually, this is just her pattern of talking. This is the cluster of phone communication between her and Charlie all the time. Not just here. So if you're just looking at this in a vacuum, yeah, it looks bad. But if they would have subpoenaed for a broader time period, then they would have seen that this is a consistent pattern. This is always how Donna and Charlie and Wendy and Katie Magbanua, this is how they always communicate. Okay, a little bit of a stretch, but that's their argument anyway. These earlier patterns would prove that whatever Ms. Adelson's communications were around the time of the murder, they were part of a larger pattern of calls and text messages between a mother and her family, not a murder conspiracy. Now, they have no evidence of this because they can't get those records. So they can't say absolutely, yes, we can show you that these records actually do exist, or they have any sort of affidavit that the patterns were always since January 2013. They're speculating. They're speculating that if they would have gotten the more records then maybe they would have seen the same type of patterns and clusters. So again, a big stretch. But the state never sought to acquire call detail records for any period before May 2014, although it easily could have done so, in the same way that it obtained Mrs. Adelson's financial records dating back to January 2013. So this is not a case where they're saying you hid exculpatory evidence, you knew about this and you didn't turn it over. No, they simply are arguing that you only requested and subpoenaed those 3 months, and you should have subpoenaed more. And if you would have, this is where the speculation comes in, if you would have seen similar patterns and clusters going all the way back forever. Since Mrs. Adelson's indictment, we have attempted to gather those records, but they no longer exist. Predictably, none of the private cell phone carriers retain records from a decade ago. Equally, if not more prejudicial, the state will likely argue that on the night Professor Markel was shot, Mrs. Adelson drove to Charles Adelson's home for a money drop, as we are all familiar with. We're going to remember that text message, which we're going to get to soon. Never mind that Charles Adelson had previously acknowledged that the money paid to Mrs. Magbanua that night came from his bedroom safe. The state likely still will speculate that this fictitious money drop occurred, and it will attempt to bolster its guesswork through a single text message from Ms. Adelson to Charles Adelson on July 18, 2014, which we all know, which reads, "Outside your house." Once again, the state is wrong. Now, they're not going to argue that she didn't actually text that. She did text that, but they're going to argue the following argument. Once again, the state is wrong. Mrs. Adelson was never at her son's home that night. Instead, she and her husband were driving from Miami to Tallahassee to be with their daughter and grandsons in the wake of the shooting. So they weren't outside Charlie Adelson's house when she texted "outside your house." They weren't outside his house. Now, why did she text that? Good question. But the defense's argument here is that she actually wasn't really there. And what's the evidence for that? Here we go. Records from Mrs. Adelson's SunPass transponder would easily prove that. Meaning, so if they would have subpoenaed the records from SunPass transponder, they would have seen that actually Donna Adelson was on the road driving towards Tallahassee when she sent that text, "outside your house." Now, why would she send that? Good question. But this is what they're arguing. They're arguing that, no, she was on her way to Tallahassee. And if they would have only subpoenaed the SunPass transponder records, they would have seen that that's where she was. But the state failed to obtain those records, and the defense cannot. It's too late already, right? It's a decade later. They don't have those records anymore. The state served multiple subpoenas on the Florida Department of Transportation for SunPass records related to Sigfredo Garcia and Luis Rivera. So it's not like the state can't do this. They've done this for Sigfredo Garcia and Luis Rivera. They've done that. But the state, aware that Mrs. Adelson routinely drove between Miami and Tallahassee to visit her daughter, including on the night of Professor Markel's murder, never tried to secure similar records for Mrs. Adelson. So why wouldn't they? Why wouldn't they subpoena those records, the SunPass transponder records of Donna Adelson? Not surprisingly, the Florida Department of Transportation no longer has these SunPass records, which could have easily been obtained by the state in its investigation. So again, more speculation that, if they would have gotten those records, then the records would have shown that actually Donna Adelson was traveling at that time. Well, what are they? Who knows? But that's what their argument is. Moreover, had Mrs. Adelson been charged in a timely manner, she would have been able to obtain those records, which would have ruled out any possibility that she stopped at Charles Adelson's residence. The records would have shown time and location entries of her vehicle on the turnpike and would have shown that the state's dangerous guesswork is wrong. Because of the state's 9-year delay, Mrs. Adelson is once again left without crucial exculpatory evidence to defend herself on this critical issue. In the due process context, the substantial prejudice requirement is met, where the state's pre-indictment delay renders key exculpatory evidence unavailable to the defendant, materially impairing her ability to defend against the charges. So here is where the argument of substantial prejudice plays in. They said, number one, they should have gotten a broader time of the records of her cell phone records, showing much more activity than just those 3 months from May 2014 to July 2014. They should have went back all the way to January 2013. They would have seen all the patterns. And number two is that they should have gotten the SunPass records, and because they didn't, because of this delay, they weren't able to obtain those. Now they can't obtain those records, and therefore Donna Adelson is substantially prejudiced. In her defense, she can't present this proof that she was not in front of Charlie Adelson's home, as well as, this is how I always talk to Charlie, all these patterns that this expert is going to testify to, all those patterns, I always talk that way. So this is important exculpatory evidence that is no longer available, only due to the state's delay. So that is their argument for the substantial prejudice. Now, their job's not done yet, because now, under the new law, as we explained, they also have to show bad faith. So this is what the argument is for bad faith. The second part of the due process analysis requires a showing that the state's pre-indictment delay was the product of bad faith. But bad faith in this context does not require a subjective, sinister motive on the part of the prosecution, as we explained. Rather, it is satisfied when the government makes a judgment about how it can best proceed with litigation to gain an advantage over the defendant, and as a result of that judgment, an indictment is delayed. That is precisely what occurred here. Rather than proceeding against every member of the alleged conspiracy at once, the state sought separate, staggered indictments, betting that the earlier charged defendants would implicate Mrs. Adelson. None did with regards to Mrs. Adelson, and an indictment against Mrs. Adelson did not follow for another 9+ years. This was not an investigative delay of the sort sanctioned by the due process clause. Virtually all of the evidence the state is likely to present at Ms. Adelson's trial was in hand long ago. The state's charging delay was strategic and in blatant disregard for Ms. Adelson's ability to defend herself against allegations nearly a decade ago. So here is their argument to saying that the only feasible explanation for why they delayed here was to gain a tactical advantage. And if that is the reason, you don't have to show anything sinister. But if that was the ultimate reason for the delay, just to gain an advantage, then that equals bad faith. So therefore, that's why they argue that the entire indictment should be dismissed. It's a due process violation, and therefore they're substantially prejudiced. There's bad faith. The entire indictment should be dismissed. That's their argument. Now, as we spoke about already, a lot of this is pure rank speculation about what those records would have shown. It's one thing if there was some real records out there that would have really shown some exculpatory information. Again, there's a lot of speculation here. But again, what would Georgia Koppelman be arguing back? So number one, she's going to show that no, the investigation did not end May 2016. She's most likely in her response going to show that they had a number of other tips, another more investigation that occurred after May 2016, which they were still gathering evidence. And remember, there's one very important evidence here that was not available 9 years ago, and that was the fact that Donna Adelson tried to escape to Vietnam, right? So that evidence obviously wasn't available earlier, and she's probably going to show how there's other evidence as well. So number one, her argument's going to be most likely this is all speculation. Number two, she's going to argue that there were a number of investigative steps that were continuing to be taken from May 2016 through the present when she was actually indicted. And number three, she's going to argue most likely is that even if we were to agree with the defense, does not equal substantial prejudice. Yeah, maybe, okay, one argument, another argument that you could be making, that doesn't substantially prejudice you. We've got so much against Donna Adelson that these areas is not going to equal substantial prejudice. And then she's also going to argue that it's not bad faith. They were actually acting in good faith. And most likely this is what we're going to be hearing. So this case is not getting dismissed. If I had to guess on this, it's a nice try, some interesting law that we can discuss on the channel, of course, which is always interesting to learn more about the law. So that was interesting. And the only question really is going to be for the judge, whether he's going to preclude this evidence of the pattern of the phone calls, which probably doubtful that he's going to preclude that. Also, that's really the only question here, whether he's going to preclude anything to do with the pattern of those phone calls and the communication between Donna and Charlie right around that time that the murder was being committed. So that is the motion to dismiss. There's also another motion, which I'd like to get into. We're not going to do it in this video, but there's another motion that was filed by Donna Adelson's legal team, and that's because they want to preclude the entire evidence of her trying to escape to Vietnam. They want to preclude it all. So we're going to be jumping into that most likely on the next video. So that's going to be it for now. Thank you all for watching. If you haven't yet, please subscribe, like, drop a comment, and we will see you next time.